All right, everybody, we're going to go ahead and get started here. Today we're talking about the buyer representation agreement. You're all familiar with this. This is where we are. We're at the greater San Diego. I often frequently misstate it, calling it the greatest San Diego Association of Realtors. There's my name. There's my phone number. There's my email address. We're going to talk today about the buyer representation agreement exclusive. I had some really good feedback the other day. I was talking about the listing input, and I was talking about the commissions that I pay other people. And it was really kind of interesting because I had somebody send me an email saying, you pay people 10%? I go, yeah. And so remember, commissions are negotiable by law, and I can pay them whatever I want to pay them. Right. So anyway, it was just kind of funny because we just had this conversation last week on the buyer representation agreement on the issue of the on paragraph number 3, which was commissions, and we were completely compliant, as you all know. All right, so we're going to talk about stuff that's going to appear to be legal. It's not intended to be legal advice. I do a lot of trial work, but usually defending brokers usually get hired by the attorney as an expert witness. Not intended to be a substitute of your broker, advice of your broker, nor for that of your attorney. Please talk to them. I'm always happy to talk to them if you would like as well. Because you came to this session, you will get an email from education@SDAR, automatically giving you copies of the material that I use during this presentation. Again, this presentation is going to be on paragraphs number 4 through 6 of the buyer representation agreement, and there weren't any real attachments to that. This morning's class, what did we do this morning? This morning we did the, I've lost it already. What did we do this morning? We had a really good class this morning, and we brought up the NODPA in that conversation as well. So I ended up sending all that information out to everybody. If you want a copy of that webinar, send an email to education@sdar.com and say, hey, could you send me a copy of that webinar and all the documents? It was actually, I thought, a pretty good one. There's my email address if you want to get a hold of me. Pretty easy to remember, kevin@burkerealestateconsultants.com. Questions. Nice to see you also. Thank you, Maria. Thank you, Maria. How to read a preliminary title report, which I'll tell you, it's chock full of stuff, isn't it? I mean, you know, we go into that class not knowing what am I going to get, but it's like, wow. And so we talked about the notice of default purchase agreement. We talked about the Home Equity Sales Act. We talked about a lot of stuff. So we definitely covered a lot of material, and I absolutely want to thank you all for being, for those of you that were able to make it to that meeting. So let's go ahead and move forward here. We're going to talk today, if I can just remember where I am. Hang on a second here. I got to pull up our material. Let's talk today about our subject matter, which is, it should be a lot easier. You will notice that as we go further and further into any of our contracts, you will notice that there's less and less for you to do to participate, but you still need to know what it says. So we have paragraph 4 through 6, we don't have anything for you to do. It's pre-printed language. You know how many people I talk to have no idea what those paragraphs say, and that's because they don't read it because there's no real input required from them. Well, what a great time to find out what those paragraphs actually say, because your client's going to ask you later. Your client may not even be at the time when you've got it in front of you that they're going to say, well, what is paragraph number 4? I saw someplace where it said something about internet advertising. And so what does that mean? Okay. Or you're going to get, and I'm going to talk about this in a second, you get that call from your buyer, you know, a year after you sold the house. And of course that, you know, always makes you nervous because you haven't talked to them in a year. And you get that call that says, how come you still advertising my property on the internet? I bought it a year ago, stop doing that. And then you have to be able to say, well, here's why. And oh, by the way, it's set it in your buyer representation agreement. So remember what I've said before about when you define your duty, you limit your liability. So that's important. Okay. So we're going to talk about 4, but I'm going to kill 5 and 6. You are going to love what we're going to talk about in 5 and 6. So paragraph number 4, internet advertising, internet blogs, social media. You're probably on it yourself. You might even be on it right now. I don't know. Buyer acknowledges, let me pull out my annotator. Y'all know I love to annotate, okay? So buyer acknowledges, let me move it up out of the way, acknowledges and agrees that 1, properties presented to them may have been marketed through a virtual tour on the internet. People have been in your home virtually, permitting potential buyers, okay, to view properties over the internet, or that the properties may have been the subject of comments or opinions of value by others on internet blogs or other social media sites. So in other words, people know what the inside of your home looks like, okay? Now the good news is this, Mr. and Mrs. Buyer, you're buying the home, you're going to do different things to it than what the previous owner, the current owner, has done to the property. And so that's going to differentiate it from you. But at the same time, you know, if they've got the Renoir, the original, you know, up there, it's not a copy, it's the original, you know, you may end up with people trying to break into your home to get that. So, you know, it's one of the risks that we face. Our cameras today are just way too good. Okay. All right. So number two, where am I? Here we go. Number two, neither the service provider nor the broker has control over who will obtain access to such services or what action such persons might take. So in other words, they might be able to see details about the property that you know, are, and as I said a second ago, in today's day and age with the camera, the ability to cameras today, those may be truly amazing pictures. Okay. Whoops. I gotta cast a thing here, participate now. So sorry about that. I have to actually cast a vote. I'm in the middle of a meeting and oh my God, this is so funny. Okay, so what's my name? Kevin. And I'm gonna vote for this person right here. Okay, send, gone. Okay, good. All right, excellent, that worked out well. Of course, I lost my lost my screen. Okay, so and number three, broker has no control over how long the information concerning the properties will be available on the internet or on social media sites. Okay, so you all been wondering, where's that information that the buyer signs off on that says that now they understand that in fact that property may still be floating around on the internet? I'm sure my house is. I should probably look it up, you know, to see what's going on. Although my one house is, you know, it's only been me for 12 years, so it wasn't, or 14 years now, but it wasn't a subject of anything on the internet. So so that's going to be my issue. My screen jumping around on me. That's going to be my issue when it comes to my client, the buyer, asking me how come I'm still, you know, trying to, you know, still have the property. You know, I already closed on it. You know, that kind of thing. Okay, all right. Let's go to paragraph number 5, and I want to talk about paragraph number 5 and number 6 as a block, and here's why. 5 and 6, and this is an assignment I usually give my students. Here's 6. Here's an assignment I give my students in my college classes. And in fact, I also give this assignment to my attorneys in my law class, which I'm teaching currently on Thursday evenings. And so here it is, paragraph number 5. In number 5, we're going to talk about broker authorizations and obligations. In other words, the buyer authorizes you and obligates you to do certain things. Paragraph number 6 is going to define the scope of your duty. And the reason that that's important is, again, as I said earlier, when you define your duty, you limit your liability. So before we did all this, people would come, you know, they would do a transaction with us. We didn't have a contractual relationship with them, something that tells them this is what I'm going to be responsible for and this is what I'm going to do. And so because we didn't have that, now the buyer would come back later on and say, you know, well, you didn't tell me this, you didn't do that, and you were supposed to do this, and you're supposed to do that. And we didn't have anything signed by the buyer that said, here's what I'm going to do. And you're going to find that this is pretty simple stuff, but at the same time, we've got to say it. And again, it is in writing, and it is you can see it on your screen. So what I do with my students is I have them break down paragraph A, for example. Here's number 1, okay? Down here, I've got number 2. Here's number 3. And I have my students write those out all in chronological, linear fashion, all right? And the reason that I do this is because when they're done with 5 and 6, in this manner, they're going to see that, in fact, that's going to cover about 1.5 pages. And I'm going to suggest that you use that 1.5 pages that you've just created as part of your listing appointment. Okay, so with your buyer, all right. So you tell your buyer, these are all the things I'm going to do for you. This is the kind of paragraph that we tend to shine over, to gloss over really fast because we don't understand what it says. And I'm going to tell you, you need to make a big deal out of what these representations are. Okay, and it's more important than you think. Let me erase some of this. I don't want to erase all of it, but I want to erase some of it so that I can show you what I'm talking about. Okay. I'm going to go back to my annotation. Here we go. All right. So paragraph number 1, buyer authorizes broker to 1. And I told you it's going to be simple. Locate and present selected properties to the buyer. Duh. That's what you do, right? Okay. Present offers authorized by the buyer. I think that this should be A, this should be little B, and 3, assist buyer in negotiating for acceptance of such offers. Okay, so I have A, 1, A2, and A3. All right, and again, I'm writing those out this way. Okay, so that now I'm putting them all in a line rather than the way you're looking at it here, where it's in kind of a word wrap. Okay, and this is why we lose concept when we're looking at this screen versus when you actually put it down. And I'm saying that because we know as an industry that people are more likely to read a list than they are to read a word wrap. So when I first got going in my business, I was working for a company and we would do a little breakdown on a piece of paper. I think some of you have heard the story already. We had it printed on what looked like parchment paper, and it said the 21 things we're going to do for you. That was my best closer. I would use that all the time, and that's how I got people to sign my buyer representation agreements. That's how I got them to sign my listing agreements. I had obviously a separate list of 21 things, but that's how I did it. I would give them a list and I would say, hey, I just want you to see these are the things that I'm going to do for you. You have to earn your money, folks, and you have to earn it up front. So when I tell you we've got people getting 10% commission on listings, they earn it. Okay. And so, that's why I say there is no standard, there's no usual, no customary, no everybody does it, no nobody will show your property unless you do it. You can't say that, Sherman, antitrust violation. On the other hand, I can tell you, I got people that do that. I got other people that do less, but the idea being earn your money, whatever that money is, whatever you think is fair for you to earn that money. Okay. All right. So we're not going to talk about dollars or percentages or anything like that because we're not going to run afoul of that. But if you understand what I'm saying, I'm going to start writing these things out the way I've got it here. Okay, you're going to, of course you do, you're going to help them find property. Of course you're going to present offers that they have authorized, right? Of course you're going to assist them in negotiating for acceptance of those offers. I saw a hand go up in the Q&A field. I can't see whose hand it was. Let me see. No, I can't see whose hand it was. If you have a question, put it in the Q&A, okay? And then we'll address that, all right? Okay, so assist buyers with the process. These are all things that just kind of, they should just go, yeah, well, duh. What else do they think that we do? They don't know, all right? How many times have you worked with a client who said, wow, I didn't realize all that you did? When I'm teaching this to the attorneys, they go, wow, y'all do a lot of stuff, okay? Yeah, we do, but we also stay at arm's length on other things. So let's look here. I'm going to assist the buyer with the financing process. Okay, I don't do loans, but I'm going to assist them with getting the financing. I'm going to assist them with representations we're going to make to the seller and the listing agent, including obtaining loan pre-qualification. We don't do qualifications, we only do approvals. Okay, upon request, provide the buyer with a list of professionals or vendors who perform the services described in the attached buyer's inspection advisory. You should look at that form, folks. Okay, we have an approved vendor list in our office that Linda has created, and that's what we send our clients when they ask us, who should I use, to do this or to do that. So we actually do that and provide it for our client. Okay, so you should have an approved vendor list, okay? And again, in your buyer's inspection advisory, I didn't pull up in here, but in your buyer's inspection advisory gives a rough, page long of things that the buyer could be doing to investigate the property. And I'll help you find people for that. Okay, I'm going to refer 3 because I'm going to avoid my negligent referral. Okay, number 4, I'm going to order reports I'm going to help you order reports. We should probably rewrite that. And schedule and attend meetings and appointments with professionals that you choose with you, right? Okay, I'm not going to go there on your behalf. You know, if you have a physical inspector, we think the buyer should be present for the physical inspection. Okay, and then number 4, provide guidance to help the buyer with the acquisition of the property. And folks, that's one of the things that you do the best. Whether you're brand new in this business or whether you've been in the business for 40 years, you kind of get it, right? You know what you're supposed to be doing. You're supposed to be helping your buyer understand the process at the same time that you're supposed to be helping your buyer get what they want, which is, yeah, we want to get this house. Okay. All right. So those are important things to know about. I'm going to erase some of these. I like to keep my little one-liner up here at the top because that's, I'm going to keep coming back to that. So you all understand what I'm doing down here when I break this down and I write it all out in segments like this. Now I'm going to see that this is going to start, you know, here I've got 2 paragraphs, 5 and 6. But when I start adding it to my spreadsheet, so to speak, it's going to look a lot more lengthy. Okay. All right. And again, these are things that you probably are taking for granted, and you shouldn't, because you really provide a valuable service, one that not everybody provides. Not everybody does what you do. Okay. Let's take a look at number B. All right. For property transactions of which the broker is aware, okay, and not precluded from participating in by the buyer. In other words, that buyer representation agreement, if you remember back on paragraph number 2, it talked about the properties that we were going to work on. Okay. Brokers shall provide and review forms. Wow, and you're all good. I'm preaching to the choir, folks. You're all good with forms, right? You attend this class, you attend my RPA class, my RLA class, you attend all these classes. So, you know, one of the things that you've been picking up as you've gone along is what forms that you need to be using. And if you're confused as to what you're supposed to be using, remember there's a free program within Zip Forms called Forms Advisor and Forms Tutor, and it is a CAR product, not the lone wolf product that you're seeing so much of now whenever you open up Zip Forms. So Forms Advisor, Forms Tutor, I was involved in creating it. The Forms Advisor program tells you what forms you need in a transaction. So in other words, as you're answering, it asks you a series of questions. It tells you what forms to use. And then the Forms Tutor program tells you how to fill the forms out, okay? So really good. I mean, it's not a substitute, again, for your broker or your attorney or even for me, but it really is a good way to learn how to do some of these things. So, you know, when we get our real estate license, we're running around going, well, what do I do now? And you know, you're all doing it, right? You're here in this webinar, but you might want to take a look at those programs. So for sure, you provide, because you're a member of CAR and you have the forms available, and you review forms to create a property contract. Remember, I always told you contract is something I'm trying to enforce, right? I usually call it an offer or an agreement, but in this case, it's a contract, right? Okay. All right. Let me, where'd my eraser go? Let me get rid of some of these things, and we'll pick it up where we left off. Okay. All right. So, for the acquisition of a specific property, with respect to such property, that specific property, broker shall, 1, if the property contains residential property with 1 to 4 units, remember, covered by Civil Code 1102 covers residential 1 to 4s, okay? Conduct a reasonably competent and diligent on-site visual inspection of the accessible areas of the property. Gosh, that sounds like what's on page 3 of my transfer disclosure statement, doesn't it? Y'all remember that? Sounds like page 3, okay? So page 3 is the part where it outlines my duty according to the Easton v. Strausberger case, all right? And those are the duties and those are the things that I'm being expected to do, okay? All right, so and then excluding any common areas, of course, and disclose to the buyer all facts materially affecting the value or desirability of such property that are revealed by that inspection. And remember, the deputy commissioner says, you know, we think you need to be doing that agent's visual inspection. You don't have to necessarily use the AVID form, but the statute says that you must conduct that. So Civil Code 2079 says that you will conduct that inspection of the premises, but we're going to limit what you have to do. So it says right in here, reasonably accessible accessible areas of the property. You don't have to dig, you don't have to poke, don't lift the carpet, don't dig holes, don't open doors that are closed, things like that. Anything that's accessible without too much difficulty. We're not going to have you go tearing the attic apart, right? Not a normal thing to do. So that's what, that's why, again, when I define my duty, which says reasonably accessible areas of the property, I'm going to limit my liability, because I'm telling you, no, I'm not going to inspect the attic, because that is not reasonable for me to do that. Okay. All right. Everybody good with that? That's kind of fun stuff. That makes it so much easier for me. So now that I know what I've got to do, deliver or communicate to the buyer any disclosures, materials, or information received by, in the personal possession of, or personally known to the individual signing for the broker below during that representation period. Remember, this is the contract with the broker and the buyer, okay? Some people call it the buyer-broker agreement, even though there really is no such document, okay? So you have an obligation, and I'm going to tell you that trumps, no pun intended, that trumps your TC holding on to everything until you sent them a complete file. No, you give it to your client as you get it. And so don't be holding things, okay? So even when somebody sends me a defective TDS, it's missing stuff, I still forward it on to my client and I say, here's the TDS that I was just sent. But at the same time, I'm going to go ahead and try to get the rest of it filled out, because I'm a little concerned about that. So I don't, necessarily use language like defective TDS and stuff like that, because that may be actually legal advice. Okay. All right. And then number 3, facilitate the escrow process. I don't do escrow either. However, I will help them with the process of finding good escrow people, making sure that they don't fall subject to wire fraud advisories, things like that, including assisting the buyer in negotiating with the seller. I'm not going to just turn you loose and say, here, it's on you now, now you go negotiate with the seller. I'm not going to do that. Okay. All right. Unless otherwise specified in writing, so express, okay. Any information provided through the broker in the course of representing the buyer has not been and will not be verified by the broker. Now, don't you love that language? So here we are now, we're saying, I'm not, any information that I give you, I haven't verified it. Okay, that's important, right? I've got enough litigation that I've had to deal with where, the agent sent stuff on to the client and then decided to analyze it and then critique it. So, remember, we don't modify things. We also don't comment on things. So, when I see a stain on the wall, I note that it's a stain. I don't say it's stachybotrys and I got to look it up and find out how to spell that. I don't diagnose it. I just have to disclose it. Everybody good? Okay, that's important. So I'm going to pass information on through to the buyer, but I'm not going to verify it. I'm just not going, I don't have to. Right? Says right here in my agreement. Folks, if no other time, now you see, I have to have this agreement with the buyer. We're always concerned, oh, gee, they're going to be upset because I'm trying to get, it looks like I'm trying to get paid. It's like I'm having them sign an agreement that forces them to pay me. I hate those words. That's like the secondary thing of the buyer representation agreement. The primary thing is creating the agency relationship contractually, okay? Prior to if you didn't have the buyer representation agreement, then, and you keep telling them you're their agent, you may be lying to them, all right? And in other states, when I'm teaching all this, I got to tell you something. They look at me and they go, yeah, what's wrong with that? We always do buyer representation agreements. There are brokers out there that will not pay you without it. Our brokerage won't pay you without it. So, that's just how we operate. And so it's pretty consistent with the rest of the country versus what you're learning in the state of Southern California. Okay. All right. So, will not be verified by the broker. So here I've told you I'm not going to verify it. I am not going to go down and pull permits. I am not going to do these things. So now I'm going to make sure that I don't come along and make representations inconsistent with that. So when I've told you I'm not going to verify it, I'm not going to now later on say, well, I'll go verify that for you. Okay, because then I just disrupted all my contractual language. And remember, that comes after the contract. And so as a result, I might be bound by that. So I want to be careful not to make those representations. When the physical inspector issues their report, it's not my job to diagnose it. It's not my job to explain the items in it. It's my job to say, here, now you know what you're buying, How you doing with that? Okay. All right. Broker services are performed in compliance with federal, state, and local anti-discrimination laws. It's just something we throw in there. It's a very important, I think it should have its own paragraph, honestly, but we just decided to add it to brokers' authorizations and obligations only because, something we do comply with those things. I hope we're all doing that. Okay. But, we just never know how people are going to behave. Are there any questions on paragraph number 6? All right, so paragraph number 6 again is going to discuss my authorizations and my obligations. I'm putting it down on paper. I'm actually saying, here is what I'm going to do for you. And that's why, my client has no problem signing this. I have had, in my couple of weeks of being in real estate, I can tell you that I have never had a buyer refuse me. And I know, like Serena, we had a buyer sign the agreement for us, didn't get any grief about it at all. They actually read part of it and they actually said, well, I want this changed. And so we were able to accommodate some of the things that they were asking us to change. But at the end of the day, they didn't have a problem signing the agreement. Now I actually have a client rather than having what the law refers to as a customer. So I have a customer until I have a written agency relationship with them, then I actually have a client. So don't be calling them a client if you don't have a contractual relationship, because they're just a customer. Okay. All right. Now there are some agents, by the way, there's some really good agents in San Diego that I know at open houses, they have the client sign this. Now, and again, I'm preaching to the choir, you're all listening to this, but you at least understand how to explain the form to people, and you understand what's going on with the form versus the 99% of the people out there that are going to refuse to do it. And then I ask them, I said, well, why do you refuse to do it? Have you ever read it? And their response is, no, I haven't. And then I say, well, why don't you read it? And so some people have this mistaken notion that real estate's really easy. Okay, well, it's really easy to not get paid. It's really easy to not really have a client, or it's really easy. Client says, well, I'll just work with whoever gets me the best deal. And then I love those. It's like, guess what? I agree with you. I'll work with the one that'll work with me. In the meantime, I'm going to the beach. Okay. So I just don't fall prey to that. All right. Any questions about brokers' authorizations and obligations? No, none. Okay. Seeing none, I'm going to move us forward to the final part of our discussion today, and that's going to be my scope of the broker's duties. So once again, I've already discussed my obligations. Now I'm going to discuss my duty. And now I'm going to remind you that duty is a legal term. Okay, so I'm not even allowed to use it. When I go to court and I'm being deposed, when I'm in trial and the judge is looking at me and asking me questions, I can't use the word duty. That's the judge's decision, right? Whether or not you had a duty or not is legal advice, and the judge's legal advice, right? So when I sit down and I read Civil Code 2079, when I read the agency disclosure form, it's going to talk about what my duties are and what I'm supposed to be doing. But at the same time, I can't use those words because those words were put together by the legislators, right? And the attorneys that created those words. They're chock full. It's like the other words I told you, not to use breach, not to use remedies, things like that, because those are legally charged words. And when you use those words, they have a lot of meaning that's probably not the same as the meaning you're intending. Okay, so we want to be careful not to use those words. Everybody good with that? So when I talk about scope of the broker duty, and remember, they're talking about the broker, the duty is what you have to do in a real estate transaction. And so again, we're talking about the broker. And for those of you who have sent this off for electronic signature, you have found that at the bottom of each of the pages is a place for the broker to initial rather than you initialing on behalf of the broker. So, I'm not going to give you legal advice. I'm not going to give you anything inconsistent with what your broker's telling you to do, but talk to your broker about whether or not you're okay initialing on behalf of the broker, because you do on the other forms, right? So talk to your broker about whether or not that's okay to do that. Just have yourself initial those, because you are the agent for the broker, right? The broker is the agent in the transaction for purposes of the law. You are the salesperson or the broker associate working for the broker. Okay. All right. So we could do a whole class on agency, but that would just make you crazy. So, I do a whole class on agency. I did a whole class for a bunch of attorneys in a deposition the other day, and they were shocked at what came out of that class. So just be aware that that is a very important subject. A really good attorney, Robert Muir, one of our attorneys on our risk management committee at SDAR, came and talked to one of my legal aspects of real estate class. I had him come in and speak. I have Jackie Oliver, Pete Selecki. I mean, these people, D.W. Duke, they're just the best attorneys that there are, right? Real estate related attorneys. And Robert Muir got up there and he said, I have yet to find a broker that could explain agency to me. I just thought that was an amazing, just an incredible thing to say. I mean, you talk to people all the time. What's agency? And I'll bet we can't answer it. And yet I love that question because it's just full of all kinds of really good stuff. And so part of what I'm explaining to you, am I the agent for you or do we have an agency relationship? A lot of times I have to create that contractually. Otherwise I might create an ostensible agency. I might create some agency that's not real. Okay. So, but that everybody believes is real. All right. Okay. All right. So let's talk about this. Let's talk about my scope of the broker duty. First of all, any questions? Let me see. I don't see any questions in there. Okay, so let's talk about the scope of my duty. And again, we're done after this page. So, but this page is going to take us a long time. So it's a lot of stuff. So previously we discussed the broker's authorizations and obligations, and now we're going to talk about our duty. Okay, all right. So paragraph number A. So let's talk about that. While the broker will perform the duties described in 6B, okay, 6B is right here. All right. Broker recommends that the buyer select other professionals, okay, as described in the attached buyer's inspection advisory. And now here I'm seeing it a second time, and I'm wishing I had pulled that up for you to see the buyer's inspection advisory. You've seen it 1,000 times. Have you read it? Okay, you need to take a look at that. So we're going to recommend that you select other service providers, okay, as described, to investigate the property. In other words, I am not the service provider, okay? My Avid does not take the place of your obligation to do a physical inspection of the property, okay? So, your buyer says, I'm going to buy it. I'll just take your word for it. Now, you need to have somebody else look at the property, maybe a relative or somebody, but I don't want to take that. I can't take that authority away from you. That's something you're going to need to do, okay? All right. Let me erase some of this so we can clean this up a little bit, okay? And then let's get back to it. Okay, to investigate the property through, and now there is a distinction here between an inspection and an investigation. So remember that you do inspections, you do a reasonably competent, diligent visual inspection of the accessible areas of the property, right? That's what you do. An inspection is different than an investigation. An investigation is more pervasive, it's more invasive. That's when you hire the physical inspector, checks the electrical outlets, checks the doors opening and closing, runs the water. All those are things that an investigation would maybe reveal things about the property that aren't functioning properly. Again, I can't make that decision. I'm not a contractor and I don't want to take that burden. But the physical inspector, make sure they have E&O insurance, make sure they're CREA approved. CREA, ASHI, NASHI, one of the approval agencies. Those are such great agencies. The state of California has decided that they don't need to create a separate licensing requirement for physical inspectors. There isn't one, right? Because they regulate themselves so well that it's not necessary for the state, at least it feels it's not necessary for them to create their own guidelines for that. Boy, good luck, right? Once they do that, it goes crazy, okay? So, all right, so through my inspection, through my investigation, this is the buyer doing this, digging, poking, the buyer can do all that. Tests, all right, surveys, reports, studies, you call it anything you want to call it, and other available information, we're just going to label it all as an inspection, okay? So we're going to just take that great big bucket, all these things that we're going to tell you that you can do, okay? This is the broker's duty is to set you up with that, but not to do those things. So to investigate, recommends that the buyer select other professionals to investigate the property through those series of things that they're supposed to do, okay? It's the buyer's obligation to do that, okay? The agent's not supposed to, just turn a blind eye to everything. They got to go into the property. They got to do their own visual inspection. We recommend an Avid. The commissioner likes an Avid, things like that. We're going to recommend those things, but that does not take the place of the buyer's obligation to do their own investigation of the property, okay? All right, so And once again, when I give the list, if the buyer asks me for a service provider, I'm going to give them a list that will include 3 of each, right? 3 escrow, 3 title, 3 physical inspectors, 3 termite, or 3 pest inspectors, whatever you're going to do, give them a list of 3 because you want to avoid the negligent referral. Okay. If you give them only 1, then, you might be, and something goes bad in that inspection, then you might, end up taking responsibility for that. Okay. Everybody good? Clear that. Okay. Buyer agrees. All right. Now this is in writing again. Buyer agrees that these inspections, to the extent they exceed the obligations described in 6B, here's 6B again, okay, are not within the scope of the broker's agency duties. Whew, boy, sigh of relief. I'm sitting there going, wow, this is great. Okay, we just told the buyer in writing that I'm not going to do this stuff. And I'm not responsible for this stuff. And don't hold me accountable for it, because I know I don't have to do it. I'm not going to do it. And I'm not going to be held liable if you think I'm supposed to be doing it. Okay, but here we've actually put that in writing, and I think that's a great thing for us to be doing. I really do. I just like that, that list of 21 things I'm going to do for you. Okay, so I like having that list. All right, but again, I'm not going to do your investigations of the property. I have an obligation to do a reasonably competent, diligent visual inspection of the property. You, the buyer, have an obligation to investigate the property. And then what's the seller's duty? Remember, okay, we have those 3 different duties, right? What's the seller's duty? Theirs is to disclose any material facts affecting the value or desirability of the property. You hear these words from me over and over and over again, and I am quoting statute. I am quoting case law. Okay, so again, not giving you legal advice, but when you hear the same thing again and again and again, you got to be starting to adopt it as your own, right? You got to be thinking along that line. And that's what's going to make you, it's what's going to separate you. You're the real estate professional. Don't worry about how much business somebody else is doing. Worry about how much business you're doing, and worry about whether or not you are doing it the right way. Okay. And again, that's why you have your broker. Those are the things that you go through. Okay. All right. Okay, and then finally, broker informs the buyer that it is in the buyer's best interest to obtain such inspections. So here we're going to tell you that again. I had a court case not that long ago. It was a great case, and literally the buyer's complaint was that that the agent was supposed to be doing all these things, and I just loved it when they presented that as part of their motion against the agent, and then the attorney, who the agent's attorney, who was just brilliant real estate attorney, and he just comes in and he just goes, well, here you signed off on it here, you signed off it on the SBSA, you signed off on it in the buyer's inspection advisory, you signed off on it here, oh, and you're a broker. So I just thought I was going to die. I just thought, wow, that's the best. What a great, listen, I work with some great attorneys. Anyway, some of them are really, really bright. So he just destroyed this guy. So, yeah, anyway, I won't get into the rest of the case, but that was a fascinating case. Let's take a look at paragraph number B. Buyer acknowledges and agrees. Now, I know you all, we're all quasi-attorneys, right? We all write this kind of language in our contracts, but when this is the pre-printed language put together by the California Association of Realtors Attorneys, and again, vetted by our risk management, our risk management committee at San Diego is going through the new RPA that's supposed to come out in December of 21, and we're looking at it, and CAR is listening to us, and they're going, oh, okay, we get it. Maybe we make some adjustments as we go along. So, some really bright minds working on all this stuff. Let's make sure that we're doing what we're supposed to be doing, okay? Buyer acknowledges and agrees that the broker, okay, this is my get out of jail free card, 1, does not decide what price the buyer should pay or the seller should accept. Now, you saw the same language on page 1 of the agency disclosure. You all remember that? On the CAR form AD, you saw the same language, okay? I'm not going to tell you how much you should pay. I'm not going to tell you how much you should take. Okay, but I need to put it in writing that I'm not going to tell you. So it's in the agency disclosure, but then now here it is again in the buyer representation agreement. I'm not going to tell you how much to pay for the property. So how do I get around that? I'll give you information that says this is about where the property should sell, right? Whether you're the seller or the buyer. I'll give you an RPR, I'll give you a cloud CMA, I'll give you something that it won't be a guesstimate, right? Okay, it'll be something that's like real, okay, and it'll be based on my professional opinion, not some database that, in an algorithm that somebody's doing in their kitchen, okay? So I'm not going to do those things, okay? But if I tell you I'm not going to do them, then you can't come back later on and sue me and say that, you know, well, I was kind of counting on you to tell me how much to pay for the property or how much I should accept for the property. And I've had those lawsuits too. Okay, so let's just remember what our obligations are. And in this case, what is our duty? Okay, all right, number 2. Does not guarantee the condition of the property. How many times have you heard me say, I'm not the warrantor of the product? If I'm selling a house to somebody, I didn't build it, right? And I tell people that. I said, I have an obligation to do my reasonably competent, diligent visual inspection, right? But I don't know what a 2x4 looks like. The threshold, it's a state exam question. I thought it's something you carried your bride over. I don't know a threshold, okay? But all those things that we had to do to take the state real estate exam, and by the way, I teach all the courses. I don't remember ever talking about that in a course, right? But there it was in the state exam. And so, you know, we all have that story, right? A lot of stuff that, you know, it's like, I don't remember seeing that at all, right? But the bottom line is, I don't guarantee the condition of this property. So if the place falls down the day after you close, don't be coming back after me. So I want to be careful now to not make a representation that's inconsistent with that. So, wow, this is one of the best built homes I've ever seen. I'm not going to say that. Please don't say that. Okay, I've been involved in a lot of construction, although I'm not a contractor, and I think this is an amazingly well-built home. Okay, those are the kinds of things that are going to get you in trouble. So let's not say something that's inconsistent. We just had them agree that we don't guarantee the condition of the property. So I'm not going to come back and say, boy, if you don't want this house, I'll buy it. Be careful about that. Okay, all right. I've actually said that before, and I've actually ended up buying the house, tickled to death to do it. It was a great deal. Okay, client didn't understand. Okay, number 3, let's take a look at number 3. Does not guarantee the performance, adequacy, or completeness of inspections, services, products, or repairs provided or made by the seller or others. So physical inspector does their thing. They have a whole separate insurance for that. Lawyer does their thing. They have a whole separate insurance for that. I am not going to be the warrantor of someone else's work. All right. And again, that's why I don't refer only one. I always refer 3. Okay. Because if I refer 1, then I'm saying, you know, I will put my life on this person doing their job. And that is not what I'm going to say. Okay. So, but at the same time, the seller goes and does work on the property. This is one of the reasons I don't like the seller doing repairs. Right. And I tell my buyer this, I said, listen, let's get a credit. Okay, and a lot of reasons for that. Number 1, sellers only got to disclose to you what they know about the property. And if you have the seller starting to tear, I had this happen not that long ago. Seller starts tearing the house apart, doing repairs for the buyer, and then finds all kinds of stuff. By the time they were done, they'd replaced an entire wall of the home, and so those were things that now they didn't know about it until they started excavating their own property. Now they know. Now they started going down that rabbit's hole, as we say. Okay, so you know you're unpeeling the onion. It's starting to get worse and worse. You know, at the same time, my buyer would have done the entire wall anyway. They were planning on doing a remodel. They're going to knock the wall out. And here's the seller replacing a wall that didn't need to be replaced because they were going to knock the wall out. Everybody good with that? I just find that people buy for their reasons, not ours. And so let's try to flesh that out. I like credits. Credits cure a lot of evil. Okay. All right. Okay, but I'm clearly not going to guarantee the performance of anybody, or certainly the seller. The seller does the work themselves. You know, it's like, oh boy, I'm not even involved in that. Okay, let's take a look at number 4. Does not have an obligation to conduct an inspection of common areas. Ugh. Please don't be running around diagnosing the pool, the community pool, or the community gates, or the guard at the front, or things like that. You don't have an obligation to inspect the common areas, all right? So then please don't do it, okay? If you start doing stuff like that, then that means you're gonna assume the risk of missing something when you're doing that. So we don't wanna do that. Or off-site areas of the property, so like there's a storage container over by a parking space or something. Like we have a lot of those in Carmel Valley where, you know, you have a parking space that's detached from the living quarters of the property. You know, maybe you don't want to be inspecting that, okay? That might be putting yourself into harm's way, all right? Oh, let me check. Anybody got questions? Okay, we're good. Okay. All right, now, Shall not be responsible. Number 5, shall not be responsible for identifying defects on the property, right? Because you're not an expert in common areas or offsite unless such defects are visually observable by what? An inspection of reasonably accessible areas of the property. Gee, we've heard that about 3 times on this page alone, right? Or are known to the broker. Now, if I'm aware of the fact that this community is having a problem with, critters or something like that, then I'm going to need to say that, okay? But again, I don't have to disclose rumor. I can just, get to the bottom line of what I actually know that is factual, okay? Number 6, seller. Broker shall not be responsible for inspecting public records or permits. Do I need to say anything about permits? I just see this all the time where the agent goes down and pulls the permits. They pull the wrong property, or they miss a permit, or they just don't know what they're doing. And listen, there are companies out there for $50, I don't know how much it is, right? But they'll go down and pull the permits for your client. So just hand your client the phone book and say, here, go get, y'all know what a phone book is. Anyway, go down and, have somebody else pull your, I don't know. I don't pull permits. I don't do stuff like that. I'll give you the phone number, 858-755-9313. And they go, what's that? I go, that's the telephone number to planning and zoning in the city of Del Mar. I got that one memorized, right? Because I am not going to make any representations that would be their job to do that. Okay, so concerning the title or use of the property, right? Okay, so is that garage remodel, into a bedroom permitted? And the answer is, I don't know. I don't know that I've ever seen the city of Del Mar actually make such a permit, but at the end of the day, turns out, of course, they farm that off to the city of Encinitas, depending on what the flavor, whatever the wind is that month, and that's how the city of Del Mar figures out what they're going to do with those kinds of things. Okay, so. But I am not going to pull public records. I am not going to pull permits concerning the title use of the property. Number 7, I will not be responsible for identifying the location of boundary lines. How many times we talk about that? Okay, how far does the property go? Well, probably goes over there and comes back again. They go, well, where's there? I go, I don't know, right? It goes over there. And we say, oh, do you mean like the fence? No, fences are put together and clearly not put together by surveyors. I don't know what that's the end of the property. Had a really good lawsuit on that where where it turned out that the what looked like a really large lot was actually 3 lots. And it turns out that the buyer was only buying the front lot. And then there were 2 other lots that were owned that were not fenced. So and here if the buyer's agent makes a representation, in this case, it wasn't the buyer's agent that did it. It was actually the listing agent said, oh yeah, it goes over to there. And it's like, no, it didn't. Okay. And you're just going to get cooked for that. Or even if you're off by 3 feet, you're going to get cooked. You're going to have a hard time. Okay. So please don't make those representations. Do not tell them where the boundaries are. As we said in this morning's class on how to read the prelim, I got the plat map. They can take the plat map down and walk. We just closed one up on Palomar Mountain where the buyer says, will you come up to the property and walk the property boundaries for me? No. Do yourself. Order a survey. Okay, it says it all over our stuff. You'll get your own survey. You can take the title company's plat map. Good luck. I'm not making any representations on that. I don't even know if you're going to find any pins up there. Okay, and then one of my favorites here is number 8. Shall not be responsible for verifying square footage. Okay, so then please don't put square footage anywhere because remember the number 1 litigated issue against real estate agents is square footage. So my MLS requires that I have square footage in there. I'm going to input that off the county tax records. I'm not going to deviate from that unless I'm prepared to defend it. Okay, so that's a very big deal, folks. Please don't put that information anywhere. Representations of others or information contained in what? Investigation reports, MLS, advertisements, flyers, or other promotional material. All right, so I'm just not going to verify any of that kind of stuff, and I'm certainly not going to give you information that is inconsistent with what you're reading about right here. Okay, all right. And by the way, remember what I said earlier, everybody refers to the RPA paragraph number 8 that says that the buyer and the seller won't litigate against each other for information that they find in the flyer or the MLS or anything like that. That doesn't protect you. Okay, you are governed by Civil Code 1088 on that. And so, you are liable for what information you put in marketing materials. All right. So, okay. Number 9, broker shall not be responsible for providing legal or tax advice. Okay, please don't give them legal or tax advice, all right, regarding any aspect of transaction entered into by the buyer or the seller. Okay, so we just don't have the ability to do that. Hi, Jane. How would you reflect the square footage of the main house and the ADU on the listing? Great question, Jane. Since first of all, I have an obligation at SDMLS to measure room dimensions, that's length times width, not volume, so not height, right? I would put in whatever the room dimension is, but when they say, well, how many square feet is that? I don't know. Well, you say the room is 10 by 10. Okay, well, I measured it, it was 10 by 10. Well, that's 100 square feet, right? I don't know. You see what I'm saying? So I don't discuss square feet. Don't even talk to me about it. Okay, I'll talk to you about room dimensions. That's fine, but I'm not going to discuss square feet. Okay, and no judge is going to convict you of that. All right. So the answer is, you want to figure out square footage, do it yourself. Okay. But again, I'm not going to give you legal or tax advice, and that's going to be a biggie. Okay, number 10, and again, remember what I'm doing, folks. I'm doing this line by line by line. I'm writing this all out. I think you should do this, right? I have my law students do this, and when they do it, then of course I run off with it, right? Because I go, oh, that's really cool. I like the way you did that, and so I'm going to save that. That's what I'm going to do, and I like to present this list to the buyer ahead of time before I have them sign the agreement. Because once they see this list, they go, wow, you do a lot of stuff. Okay, and I hate to tell you this, but in some places where you go, they're going to go, yeah, I know you do all this stuff. Okay, because I sign these all the time. All right, okay, all right. Number 10, shall not be responsible for providing other advice or information that exceeds what? The knowledge, education, experience required to perform real estate license activity. By the way, that information required to obtain a real estate license, that is the standard that you are held to, is the standard that it takes, the information, the education that it takes to get a real estate license. All right, so that's all you're held accountable for. All right, now when you go beyond that, when you give advice that is beyond that, you're creating your own problem. Okay, so remember, since I'm limited, the law says all I have to do, whatever, where did it say in my educational material when I got my real estate license what a stem wall was? Anybody know what that was? I had a really good lawsuit on that. Okay, and it's like stem wall, and so it was some kind of cool thing that this person heard. And next thing you know, they're saying, well, there's a stem wall over there. Well, it turned out it wasn't a stem wall. It was something completely different. Okay, and so they shouldn't have represented that. All right, okay, so don't go beyond your field of expertise. Don't go beyond your range. All right, and that's what we do. We do that all the time, and we get so proud of ourselves that we know something, or we take these little classes, like these little webinars, and we learn some really new things, which is really cool, right? But then we got to be careful not to get diarrhea of the mouth when we're having this conversation with our client, and we start talking about, like I have a graduate degree. Well, first of all, I got a law degree, you know that, okay? I don't give legal advice to my client, right? Clients ask me all the time, well, legally speaking, and I go, don't know what to tell you. I've talked to an attorney about that. Anytime you use the word legal in a sentence, I'm going to refer you to counsel. I'm not doing that. My email signature line says, you engaging me in business is going to be a real estate relationship, not a legal relationship. I'm not going to be giving you legal advice. I'm just not going to do it. Okay. All right. And you should take that same approach. Okay. I can counsel you on real estate. I can't counsel you on the law. I'm clearly not going to be qualified to counsel you on taxes. God knows taxes, changes 1 minute to the next. Can you believe we're not having to file our taxes until today? I mean, God, it's always April 15th, right? Okay. All right. So anyway, I'm held only to the knowledge it took for me to get a real estate license. And that's what this says. Buyer agrees to seek legal, tax, insurance, title, and other desired assistance from the appropriate professional. And I always say, I am not that professional. And then they look at me and they go, well, you're pretty professional to us. And I go, yeah, I know, but I am not that professional. I'm not the legal professional. I'm not the tax professional. I'm not an architect. I'm not a stager. I'm none of those things. I don't carry any of those credentials. Not interested. Okay. And you all need to be proud of that. You need to be able to say, you know what? I can't counsel you on that. I don't know what to tell you. All right. Everybody good? Okay. Let's go back again. Now I keep writing this up here. Some of you have come in, checked in late. And when I'm doing that, I'm talking about how I write this out. And then I have my client see this or even sign it before they do the buyer representation agreement. Okay. All right. Let's talk about paragraph number C, and then we'll call it a wrap. So this is going to be a continuation of a theme. Just check and make sure I don't have any other questions. Okay, so it's a continuation of a theme. Broker owes no duty to inspect for what? Common environmental hazards, earthquake weaknesses. Now, what are we talking about here? We're talking about like lead-based paint. The property's built before 1978. I know I've got to give them the lead-based paint addendum, okay? I mean, I still have to disclose things, but then we have a special addendum for properties that are built prior to 1978, right? If a property is built before 1960, then I've got to give them the earthquake hazards report, right? All these are in your environmental hazards booklets. And by the way, I'd be making sure that I'm having my client get those when I'm doing rentals as well. It's not just for sales, okay? All right. Or geologic and seismic hazards. Gee, those are starting to sound like my NHD report, right? So I don't have an obligation to do any of that stuff. The seller does by statute, and that's Civil Code 1103.7. Okay, so the seller has that obligation. I don't. I just have an obligation to give them the report that is obtained by the seller. Okay, all right. So if the buyer receives, oh, here it is, environmental hazards, a guide for homeowners, buyers, landlords, and tenants. Okay, so if they receive it, and if you're doing a transaction with me, it's in a rental, it's going to be a separate 6 documents that you're going to get on the rental. But if it is a home for sale, we use property ID, and they include all this in the property ID. Okay, you use whatever natural hazard company you want to use. We just like that property ID because we know how to read the reports, and they tend to be fairly good. Okay, remember that if you make a mistake on whether or not a property is located within one of those zones, 6 zones identified by the state of California, if you make a mistake, the courts have held that the only real remedy for that is going to be you're going to have to buy the house back because you can't move the house out of the zone. All right. And it's usually because the property's in the zone. The seller says, there's nothing wrong with my house. No, 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 no. Okay. All right. So I'm not going to take the heat for that. Okay. So, the homeowner's guide to earthquake safety, the commercial property owner's guide to earthquake safety, et cetera, et cetera. Those are all going to be documents that I'm going to provide the buyer in the real estate transaction. The booklets are deemed adequate. Got it? Now the lawyers are saying that the booklets are deemed to satisfy the statutory requirement, okay? To inform the buyer regarding the information contained in the booklets, and other than as specified in 6B above again, broker is not required to provide buyer with additional information about the matters described in the booklet. So, the booklet talks about soil liquefaction, for example. It's on all of my tests, on every test that I give my students in all the colleges. It's always there. I just like to say soil liquefaction. 99% of the people I know don't know what that is. Okay, and so I do. I know what it is, right? The soil is of a certain viscosity. There's a certain ground shaking that triggers the event where things can actually slide into the ground. We saw that in the Agua Prieta earthquake up in San Francisco back in 1984, if you can believe it was that long ago. Okay, that big earthquake up there where we had buildings actually moving into the ground. They don't disappear, right? Well, I don't know, maybe they would, right? I don't know, I can't comment on that, but that's what soil liquefaction is. Okay, we've got it here. We've got it at Point Loma. There, that area, some parts of Point Loma are very viscous. That a certain type of earthquake might cause, some soil subsidence, things like that. But again, I'm not an expert on that, right? But I can sure read, and the natural hazard disclosure reports that are out there tend to have that. The good ones tend to have that information in there, okay? So, but do I have an obligation to explain to the buyer what soil liquefaction is? No. Do I have an obligation to give them examples of my experiences with it? No. Okay, I have an obligation to give them the report. And in fact, if you'll notice in your natural hazard disclosure form, there's a place for the seller to sign, the transferor. There's a place for the listing agent to sign, but there's no place for the buyer's agent to sign. Okay, they just leave it open. They say agent, but there really is no requirement statutorily for the buyer's agent to sign it, but the buyer's agent is tasked with making sure that it is delivered to the buyer. Okay, so those are really important concepts to keep in mind. So once again, when I go back into my information here, I'm going to be looking at paragraph number 5, and paragraph number 6, I think that you should write them out. Again, if you're newer in the business, you're more likely to do it. If you've been around a while, you're going to go, why would I do that? But here's the thing. Okay, so I'm going to do this, 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 this. I'm just going to do them all sequentially rather than the way they are right now, which is in word wrap, because I want to be able to make sure that my client understands I do a lot of stuff, and they're more likely to be impressed with the list, so spreadsheet, if you will, versus the word wrap. Not like we said in the very beginning of our presentation today, paragraphs 5 and 6 are the paragraphs that most people just gloss over. You know, they don't even read it. Why? Because there's nothing to do there. So they figure it mustn't be important. It's probably the most important part of the buyer representation agreement. All right. So my advice, my encouragement is that I would probably write these issues out. I'd probably write these things out so that you've got them on a list. I would present that list to the buyer at the time of your buyer's appointment, you know, because remember, we never meet the buyer at the property for the first time. I truly believe that the more time you spend with your buyer in the beginning of the transaction before you even show property to them is worth all the time in the world that you're going to do later, because, you know, the rest of the time you're just going to be playing catch up. But if you are doing this in the beginning of the transaction, you're explaining to the buyer what you're going to do, your buyer is far more likely to sign the agreement, for one thing, and agree that you're probably worth the value of whatever it is you're going to charge. So in paragraph 3, when you put in how much you're charging the buyer, then you know, you've now perhaps earned your money. And if your buyer, after looking at all this that you've typed out, doesn't think you're worth your money, then maybe you need to find another buyer. Okay. But, you know, it's true. There are always going to be people out there. I'll work with the one that finds me the best deal, or I like to work with everybody. I like to play the field. It's kind of like, you know, just I like free dating, you know, whatever. I don't know. Okay. But at the end of the day, I want to work with someone who wants to work with me and someone who's willing to commit with me. And that's why I use the buyer representation agreement. Everybody in our office does. And we never have a problem with people signing them. So are there any questions about any of that? That we covered a lot of material today. Let's see, Jane, square footage. Yeah, I hate square footage. You know, the square footage is the asbestos of our day. You know, back in the 80s and 90s, everybody was freaking out about asbestos and lead-based paint and all that kind of stuff. Today, it's square footage. I just don't mess with it. I'll take whatever the tax record shows, but I'm not going to put anything different on any reports, or I'm certainly not going to put anything in writing anywhere. I just want to make sure that I'm not making misrepresentations. And Maria, thank you again. Reading the title report, I couldn't even think. I mean, I had a lot of distractions, of course. I always have an excuse for why I'm brain dead, but I want to be able to help you in any way that I can. Hi, Galena. Describe one more time 5B3, facilitate the escrow process, including assisting buyer in negotiating with the seller. Absolutely. Absolutely, Galena. Thank you for asking. So let's go back to 5B. Let's take a look at that one. And what Galena is referring to is 5B, which is right here, and it was little number 3. So when I get down here, 3 is I will facilitate the escrow process. So I will send a copy of the agreement that the buyer and the seller have signed to escrow. So I will help them. I don't do escrows, right? I'm not an escrow officer or an escrow agent, whatever that is. But I will help the buyer with the process. And when the buyer calls me up and says, I just got a whole bunch of things from the escrow company that says general provisions, what's that? And I explain to them that our contract is the escrow instruction, but now the escrow company will send essentially the fine print, which says, you know, please don't sue us because we're just taking your instructions. And those are called the general provisions. These are the things that we are going to do. These are the things that we aren't going to do, much like this document. So I really think you need to be using this document, including assisting the buyer in negotiating with the seller. So, you know, we're going to assist the buyer. We rarely ever have the buyer meet the seller. We find that tends not to necessarily go well. And part of that reason is because a lot of people think of it as an adversarial process. I don't think that it is, but I can tell you personally, just last week, I had a situation where the buyer and the seller met independent of me. I wasn't present. And now it's like, okay, well, what did you all agree to? And so then the buyer I said, write it down. I'm not going to take what you tell me. They write it down. I send that off to the seller's agent. And they said, that's not what we agreed to. right? That's why the statute of frauds says that in order to, an interest in land, in order to be enforceable, must be in writing. And that's why this has to be in writing, okay? And there you go, perfect example. Everybody we agreed to something, but nobody seems to know what they agreed to. Everybody's got a different idea of what that agreement looked like. Okay, all right. So I will help the buyer in negotiating with the seller, but again, it's the buyer's negotiation. I'm just the middle person on that. Okay, unless otherwise specified, again, in writing. So express any information provided through the broker in the course of representing the buyer has not been and will not be verified by the broker. I haven't verified anything you've said. I can't verify that the physical inspector knows. Remember, you're making the decision on who to hire for the physical inspection, and so I just can't make any representations. I'm not qualified to diagnose their work or to critique their value or anything like that. Does that help, Galena? I want to make sure I'm answering your question. I might be beating around it a little bit. Describe one more time 5B3, facilitate the escrow process, including assisting the buyer in negotiating with the seller. Yeah, I'm here to help. But at the same time, you're buying the house. And I always tell people that, you know what, for me, I come at it from a different position. I come at it from the position that, you know, you're the one making the payments. I'm not going to make the payments. And so as much as I'd like to help you with that, you're buying the property. Remember, I'm not the warrantor of the property. At the same time that, you know, if you've got concerns about something, I suggest that you, thank you, Galena. I suggest that you research it, you look it up, okay? But at the end of the day, you can't say that you thought I did your job for you. And listen, the judges are very clear about that. And when they're sitting up there and you're, you know, I love it. I just had a transaction where the listing agent put in the transfer disclosure statement. This is language we haven't seen probably in 25 years, where, you know, recommend buyer get physical inspection by licensed contractor. And then you're sitting in court and the judge looks at you and says, you know, why are you shirking your 2067 duty of inspection and disclosure, 2097 inspection and disclosure? And the agent's going like, well, I thought, you know, that was the buyer's job. It's like, yeah, I know, but you still have an obligation to do a reasonably competent, diligent visual inspection of the premises, not pass off your duty to the buyer. You know, your job, you still have a job to do in this transaction. And so I just love it when the judge starts yelling at people. That's always, you know, we call it the laugh test, right? When the judge starts laughing uncontrollably, you know, you've lost your case. So hopefully that helps. Other questions? Seeing none. Tomorrow, what are we doing tomorrow? Tomorrow we're doing, are we doing zip forms tomorrow? I think we are. I'm pretty sure we are. Let me check here. Hold on a second. I think we're doing zip forms in the morning, right? No, we're doing fast stats. Oh, fast stats. No, that can't be right. Are we doing fast stats? Yeah, we are. We're doing fast stats tomorrow. Fast stats are cool. I'm going to show you how to become a market expert all of a sudden without using the word market in a sentence. And then in the afternoon, we'll be doing so that's at 10 o'clock in the morning. Then in the afternoon at 1 o'clock, we'll be doing the RPA, and I can't remember what paragraphs we're on, but we're moving along really nicely. Oh, Jane, thank you. Nice haircut. Oh my God, look at I missed all these messages. Very well. Have a nice afternoon. Nice haircut. Thank you. Yeah, I did. I told the guy, I said, I've been going to this guy for years. And I said, listen, short, right? Linda says, you're starting to look like one of the Beatles. Half of them are dead, right? One of them just turned 80 the other day. Ringo Starr turned 80. So thank you, Jane. That's very kind of you. Very funny. Thank you all for being here. I appreciate you more than you can possibly know. You're wonderful. If there's anything I can do to help you, would you please let me know? And I look forward, hopefully, to seeing you tomorrow. Okay, y'all take care for now. Thank you much. Be good. Bye-bye.